All right, now we're going to turn to a story that we broke earlier today on WKBW.com. The young man already convicted of killing 10 black people inside the Tops supermarket in Buffalo more than 2 years ago is asking that his federal death penalty case be dismissed, with his attorneys arguing it's unconstitutional. So these motions were just filed in federal court, and there are several claims in these new documents. First, that the case isn't, quote, in the public interest. His attorneys also argue it's unnecessary because the case is duplicative since he already was sentenced to life in prison on state charges. The attorneys claim the federal hate crime statute is unconstitutional. And then finally, they argue the shooter is exempt from the death penalty, or should be, because he was 18 years old at the time. The public defenders who are representing him write, given both the consensus in the scientific community and evolving community standards, this court should bar the government from seeking the death penalty against Payton Gendron under the 8th Amendment. His age at the time of the offenses should categorically exempt him from capital punishment. Paul Cambria is a local attorney, legal analyst, and constitutional expert, the perfect person to help us try to understand this. Paul, thanks for coming on. I know that this was a very lengthy motion, actually two separate motions, sort of seeking dismissal or asking the judge to take the death penalty off the table here. What do you make of the arguments from the shooter's attorneys?
Well, the one thing that's kind of interesting and a little bit ironic is that one of their main arguments that the statute is being applied, the federal hate crime statute is being applied unconstitutionally, rests on the 13th Amendment, which is the anti-slavery amendment. And basically what they're saying is that that amendment doesn't authorize Congress to implement a statute such as this for what they call a private assault, that it's more directed to so-called badges and incidents of slavery, like depriving someone of the right to vote or the right to contract, etc. And so it is kind of interesting that they would use the very slavery amendment to try to invalidate this particular provision in a situation where the case has racial overtones everywhere.
Yeah, the irony is very deep on that. We never, Paul, never want to forget the impact that this continues to have on the victims' family members and our 10 neighbors and friends and family members who we lost a little over 2 years ago. I know that the federal prosecutors, the U.S. Justice Department, obviously keeps their wishes in mind. I would imagine they will file a response to these motions, basically telling the judge, no, this is a case that needs to go forward. How do you think they'll respond to this?
Well, no doubt about it. I think they're going to take the position the federal law is a law unto itself. It has, goals and so on that Congress thought and felt that were justified and that it should be upheld. And if anything, the 13th Amendment should underscore what the authority is of Congress, as opposed to saying an anti-slavery law prevents a racially motivated prosecution. I mean, that really is kind of a unique kind of argument. I personally don't think that it's going to go anywhere. I think that the courts will find that this statute can be employed, and that it'll be employed to conclusion.
The other thing, Paul, finally here is their argument that Payton Gendron was 18 years old when he committed these crimes, and that therefore he was essentially too young, I guess, to have known what he was doing for it to rise to the level of a death penalty case. What do you make of that argument?
Well, there have been many cases over the years deciding the age, you will, of responsibility. And 18 has been a very recognized age in the federal law that someone can be treated as an adult and they can be prosecuted as an adult when they're 18 years of age. If you think about it, you can serve in the military and lose your life defending your country at 18 years of age. And so here, that argument is being made And also they're making an argument under the 8th Amendment, which is the cruel and unusual punishment amendment of the Constitution, saying that someone, this young to be prosecuted, put to death if he's convicted, violates that amendment. I do think that most of these arguments have been made in other contexts and have been rejected once somebody reaches at least the age of 18.
More coverage on this on our website, WKBW.com, where we went through those documents. Attorney Paul Cambria, thanks so much, Paul. Good to see you.
My pleasure.